Who needs an estate plan? Chances are you do. You may think that estate planning is just for the wealthy, but it's not. In fact, an estate plan may actually be more important if you have a smaller estate, because your final expenses will have a much greater impact on your estate, and there's a much greater possibility that your loved ones could suffer from a lack of financial resources. The fact is, without an estate plan, you can't control what happens to your property if you die or become incapacitated. Generally, people create estate plans because they want that control. They also want to make sure that their wishes are clear in order to avoid any family disputes. In addition, they care about preserving their property for loved ones and want to make sure that their loved ones are properly provided for. An estate plan is especially important if your spouse isn't comfortable with financial matters. You have young children who need a guardian. You have an estate that will be impacted by estate taxes. On the federal level, that means estates that are several $million. This changes with tax law changes. So as always, check with your CPA. That's because the IRS will only impose estate tax on estates over that amount. We'll go into that more in detail a little bit later. Also be aware that this amount may be lower on the state level. States impose their own estate taxes, and each state has a different exemption amount. Estate planning is also particularly important if you own property in more than one state, you have privacy concerns, or you have other distinct needs, for example, planning for the succession of a business. Let's talk about health care directives first. You can leave instructions about the medical care you would want if conditions were such that you couldn't express your own wishes. There are 3 different ways to do this: a living will, a durable power of attorney for health care, which is referred to as a health care proxy in some states, and a do not resuscitate order, or DNR. A living will is a document that lists the types of medical treatment you would want or not want under particular circumstances. For example, your living will might state that you would not want life support if you fell into a persistent vegetative state. With a living will, you have to think about all possible scenarios where you would want specific action to be taken, and then put your wishes in writing so that the reader will clearly understand them. A durable power of attorney for healthcare, or healthcare proxy, lets one or more family members or other trusted individuals, who are called agents, make medical decisions for you. Unlike a living will, with this type of healthcare directive, you don't have to envision specific circumstances. You simply grant authority to your agent or agents to make decisions for you. A do not resuscitate order is used for a different purpose. Let's say that you're in the hospital lingering and suffering with a terminal illness, and you don't want the hospital staff to take life-saving measures if you suddenly go into cardiac or respiratory arrest. To make sure your wishes are carried out, you may be able to get your doctor to issue a DNR. A DNR is a legal form signed both by you and your doctor that's posted by your bed to give staff members the permission they need to carry out your wishes. Be careful if you're using a DNR. Some states require their own DNR form, and some states require one DNR form if you're in a hospital and a different DNR form if you're in a nursing home. Be aware also that some states don't recognize some of these healthcare directives, so depending on your state, you might need 1, 2, or all 3 of these forms. All of us make plans that are based on the possibility that a specific event may occur. Many of us carry more than the minimum required amount of auto insurance because we recognize the possibility that financial loss could result from an accident. Since it's 100% certain that each of us is going to die at some point, you might think that everyone would have an estate plan. The fact is, that's just not the case. So, what happens if you die with no estate plan? If you own property jointly, that property may pass automatically to your joint owner upon your death. If you have an IRA or retirement plan, or you own life insurance, funds may pass automatically to your designated beneficiaries when you die. Similarly, property held in trust may pass automatically to a designated beneficiary. In general, however, the property will pass according to the state intestacy laws. These laws govern the disposition of property when someone dies without a will, or with a will that doesn't account for a portion of his or her estate. A will is probably the most vital piece of anyone's estate plan. A will is a legal document in which you direct how your property will be dispersed when you die. It also allows you to name an executor who will carry out your wishes, which are stated in your will. In addition, your will lets you name a guardian for your minor children. You can also create a trust in your will. You can use your will to accomplish other estate planning goals as well, such as tax planning. To be valid, your will must be in writing and signed by you. Your signature must also be witnessed, although the number of witnesses required varies from state to state. These requirements are important because if you aren't careful, your will may be invalid. So see an estate planning attorney to take care of this for you, and avoid any do-it-yourself solutions. Now there's one big consideration to having a will for some people, and that's the fact that wills generally have to go through a process known as probate. Most wills will have to be probated. The rules vary from state to state, but in some states, smaller estates are exempt from probate or qualify for an expedited process. So what does probate entail? Probate starts with someone filing the will with the probate court, which will then oversee the estate settlement process. Usually the person named as the executor in the will does this. Once the will is filed with the court and validated, the executor can go about the business of settling the estate. This means collecting monies owed to the person who died, such as wages, paying any outside bills, filing final income tax and estate tax returns if necessary, and then distributing the remaining property to the rightful heirs. Usually, everything goes smoothly during the probate process, which typically lasts anywhere from a few months to a year, depending on the size of the estate, as long as the executor does what needs to be done in a timely fashion, and there are no family squabbles. Nevertheless, some people may want to avoid this process. Before we look at reasons why you might want to avoid probate, let's review the positive aspects of probate. For most estates, there's usually little reason to avoid probate. The actual time and cost involved are modest, and it just doesn't make sense to plan around it. And there are actually a couple of benefits from probate. Because the court supervises the process, you have some assurance that your wishes will be abided by, and if a family squabble should arise, the court can help settle the matter. Further, probate offers some protection against creditors. As part of the probate process, creditors are notified to make their claims against the estate in a timely manner. If they do not, it becomes much more difficult for them to make their claims later. But for some complex estates, probate can be more burdensome and taking up to 2 years or more to complete. This could tie up property that your family may need immediately and also increases the costs that can arise, such as executor fees, attorney fees, and insurance cost. And if you have real estate in more than one state, for example, if you own a summer home in Maine and a winter home in Florida, your executor will have to file in each state where the property is located. This is referred to as ancillary probate. Additionally, wills and other documents submitted for probate become part of the public record, which may be undesirable if you or your family members have privacy concerns. If any of these issues are a concern to you, an estate plan can be designed to limit the assets that pass through probate, or to avoid probate altogether. The major ways property is passed outside of probate are by owning property jointly with rights of survivorship, by ensuring that beneficiary designation forms are completed for those type of assets that allow them, such as IRAs, retirement plans, and life insurance, and by putting property in a trust, and by making lifetime gifts.